have to say that the title of my presentation is a nerdy title that Judge Kovac wanted to avoid with his inspiring isms, and a lot of issues have already been raised, and I do hope that I will be able to offer at least some new insights. So after a brief introduction, I will highlight some methodological dilemmas and concerns, and then I will look at the effects and effectiveness through different lenses. Different approaches that have been used in literature and policy documents, and different approaches that I think should be part and parcel of the analysis and perhaps haven't been addressed sufficiently so far. And given that we professors like to talk a lot, I really hope I will be efficient and effective enough, at least time efficient, and finish and make it up to the conclusions in the 20 minutes that I have at my disposal. So, why are we assessing effects and effectiveness now? Well, the title says itself, ICC at 25, so it's a quarter of a century. And even if you look at 2002 as the birth date of the court, it still would be 21, so it would be a fully fledged responsible adult. And perhaps the time has come to assess it to different standards than at the beginning. And of course, this is not a revolutionary idea that either I or organizers of this conference came to. There have been a number of efforts taken by a variety of stakeholders, and we don't have time to go into all of these. But what I do want to mention that in addition to International Bar Association, Human Rights Watch analysis, plenty of academic literature on this issue. As we heard earlier this morning, even the ICC and the Assembly of State Parties realized how important this is and commissioned an independent experts to conduct a review, and the extensive report was published in 2020 with almost 400 recommendations, which are very practice-oriented, as we heard. And the review work continues in the form of a review mechanism. And also a lot of efforts to address the issues of efficiency and effectiveness have been made by the ICC itself in its strategic goals, and the newest strategic goals are for this period of 2023 to 2025. How is this to be done? There is actually no consensus in the literature on what are the right metrics, what are the right lenses that we should use. And in addition to those that I call the naysayers, that reject the legitimacy of the court altogether and believe that the court cannot be effective given that the major powers are not member states, there are different approaches that we can take. The first one, epistemologically speaking, is to look at it from a more theoretical perspective and to look at the logical consistency, internal consistency of the court functioning, and also to look at the values and symbolic values that the court is set to achieve. Also, we can look at it from a more evidence-based approach through empirical studies, either by doing case studies, looking more qualitatively, comparing it either with other tribunals, as we heard, with other bodies or itself, or we could also look at it more quantitatively, statistically, looking at facts and figures. Also, most of the efforts so far have been external, although the independent expert reviews took into account the thoughts and ideas from the personnel, of course. But there is also some focus, recent focus has been pointed to internal perspective in a research which took into account what the personnel, what the members of the defense, of the chambers, of the prosecutor's office think about what the goals should be, of how effective the court is, and whether these goals have been achieved. And what I have to say that even within the court there is divergence. So even within the court there are different views as to what the court should achieve and whether this has been done. So starting from the qualitative, I would say starting from facts and figures, I think is the easiest approach. We can look at effectiveness as efficiency, the degree to which maximum productivity is achieved without wasted energy or efforts, and what would be the indicators if we take this approach. Of course, we can start from a number of cases, and here I use cases in a broad sense, so we can look at number of preliminary examinations, I think 3 at a time, number of situations under investigations, a number of confirmed charges, number of convictions, number of arrest warrants, etc., etc. We can also look at the length of the trial, or length of certain phases, pre-trial procedures and proceedings have been highlighted quite a lot for their length and their purpose as well. And then we can look at the budget. And this is actually, for example, and this is an approach which is often taken when we consider and discuss effectiveness of the court. For example, if you look at the European Parliament briefing on the occasion of the 20th anniversary, so 5 years ago, the title effectiveness started exactly with the numbers. And the briefing said there were only 3 final convictions so far in 2018, and the budget was almost 148 something million dollars, an increase in the budget as well. And also, if we take a look at the ICC strategic goals, we will see that raising effectiveness and efficiency is #1 strategic goal of the ICC, and that it is believed that by raising efficiency and effectiveness, we will pursue the goal of universality and that more member states will join. And then there are concrete measures that should be taken and followed. For example, exactly how many arrest warrants will be issued within this time frame, how many counts will be confirmed, and whether the judges will meet the targeted deadlines that they set in chambers' practice manuals in order to expedite the proceedings. Of course, this can be a starting point, but it cannot be an ending point, right? First of all, we have to be careful about the selection of measure time. Obviously, we heard also earlier this morning, when you set up an institution, you have problems associated with building the institution, with building the jurisprudence, whether interlocutory appeal is allowed or not. Different chambers diverge on these issues. So obviously, we should not have the same lenses with respect to the first 10 or 15 years and today or from now on. Also, the number of cases, of course, is not correlated with the outcome of these cases or their quality and fairness of proceedings. And even the OTPs in one of its policy documents stated that actually even if there are no cases, that would be an indicator of successfulness of the court because it would mean that the nation states did the job. So there are different angles to look at it. And we also heard about the acquittals. There are also they vouch to the fairness of the process, right? So there were no sufficient proof to beyond reasonable doubt. So looking only at numbers of cases convicted or counts confirmed is also, I would say, a very narrow approach. And it's also not about the number of these issues, but whether they are complied with. And especially we see it in the situation of arrest warrants, with which we oftentimes have problems. And I don't have to go into the question of cooperation of states. I think it's something that we all know a lot about and that we are worried about. But I want to mention the positive complementarity. It's a court of last resort, so of course the number of cases and in light of especially positive complementarity which was developed is perhaps not the only or the best approach to use. So what are the other possibilities? We can look at it from social sciences perspective and also look at the plain meaning of the word effectiveness. So an action is effective if it reaches the result, if it produces the desired result. So what are the desired results of the ICC? To paraphrase Seneca, no wind is favorable to a ship without a clear destination. So we first have to identify what is our desired destination to be able to assess whether the winds blew in the right direction, so to say. And of course, there are different types of goal. Official, by the mandate providers, we can look at the preamble of the Rome Statute. Operative goals, such as in strategic documents that I already mentioned. External, then also internal goals, as seen by the personnel of the court. Long-term versus short-term goals. Explicit, and those which are perhaps non-stated, for example, whether the court should provide a historical record. So identifying these goals may not be that easy. And to quote Shaney, there is a goal ambiguity. To further quote Professor Damashka, there is a goals overabundance. And these goals sometimes pull in different directions. So there are internal tensions between these goals. And we can also ask ourselves whether the court itself is institutionally competent to realize all of these goals. And this brings me to the issue of deterrence, because deterrence is often, in literature at least, perhaps the most often used metric, perhaps the most often used lenses. And if you look, of course, at the Rome Statute, we will see that its aim is to put an end to impunity, also something that we heard about, and thus to contribute to the prevention of such crimes. But this is, of course, an elusive goal. And Professor Sheibas has said, we can easily point out to those who were not deterred, but how can we point to those who were deterred? How can we measure it? And there is also a problem of correlation. For example, the number of child soldiers dropped in Ituri after the Lubanga charges and conviction, but later on rise again, according to some research. And it's also, there has been recently some empirical research which proves or tend to show that ratification of the Rome Statute itself had a positive effect. However, you can argue that the states that have positive human rights record ratified the statute in the first place. But for example, Benjamin Appel found correlations saying that their human rights practices even improved, whereas with respect to states that did not ratify the statute, these human rights practices remained the same. There is also, however, research that the actual involvement by the ICC in situations prolongs the conflict, in certain, at least, situations. So there is still a lot of space for further research, but it's also difficult to reduce the correlation to just involvement of the ICC and not to take into account a myriad of other factors. And of course, deterrence is premised on the idea that we are dealing with rational calculators who will take into account costs and benefits of certain conduct. But are we really dealing with rational calculators in situations of heavily emotional armed conflicts? So that's one question. And then again, isn't it paradoxical to place, all in one bucket of deterrence, or to place deterrence on the pedestal, having in mind the selectivity of the court and weak enforcement chances? And even Cesare Beccaria in the 18th century said it's the certainty of punishment which matters to the criminals, not the height of the penalty, for example. And here we are far away from a certainty of punishment for those committing international crimes. So instead of focusing on deterrence, there is a plea in literature, at least, that we should perhaps focus more on prevention through building a culture of accountability, through pedagogic function, something also similar to what has been said this morning earlier, through fair proceedings which can serve as a basis for others to implement interpretations that can be followed by others, by norm internalization, to quote Harold Coe, and encouraging domestic processes. All also very difficult to measure, I would say. And then we can also look one metric which has also been heavily used in literature by feminist legal scholars, is adherence to gender justice. And we can, if we only look at the Rome Statute, we can see that it has made huge improvements. Also, there have been improvements by the ICTY and ICTR jurisprudence, seeing sexual violence as genocide, as different types of war crimes, as torture, etc. But now we have a first international instrument which defines gender, perhaps in a little bit controversial, or perhaps the definition itself could have gone further, but we have a definition of gender. We have explicit incrimination of different forms of sexual violence as underlying actions of crimes against humanity and war crimes. And we also have a form of crimes against humanity, a new form of gender persecution. And some of these issues have been further developed through policy paper, for example, policy paper on sexual gender-based violence, which is under review currently. But it further brings social elements, social construction of gender into the picture, and it also introduces the notion of sexual and gender-based violence, and there is also policy paper on gender persecution in 2019, and a lot of special advisors to the OTP, which all have look at gender issues from different perspectives. And also exciting breakthroughs have been made through the case law. I here mention Bemba, even though the decision was overturned on the appeal, but it condemned sexual crimes committed against men and boys. There is also Ntaganda, and we could call it perhaps judicial activism in a way, because in Ntaganda, in Bosco Ntaganda judgment, intra-party sexual violence, not just against protected persons from the other side, but against child soldiers within his units, it was decided that it constitutes a war crime. And then, of course, recently Ongwen, in which forced marriages were seen, I would say, not just as sexual slavery, but it was recognized there is a whole other gender dimension for slavery within it, servitude, a myriad of other issues, and that this is better captured through other inhumane acts. We have first charges of gender persecution in Hassan, followed by other charges of gender persecution. So we see a lot of developments in this area. And I want to emphasize that gender mainstreaming has been also set as a strategic goal of the ICC itself, not just anymore of the OTP. So gender perspective should be taken into account, not just when we think about indictments, when we think about charges, etc., but also within all the aspects of the court's work, when we think about recruitment and personnel of the court, but also when we think about reparations and the fact that harm, that there are different dimensions of harm according to gender lines as well. And so finally, there is a lens that I think hasn't been included so far or sufficiently within the discussion, and that is inclusion of post-trial or lack of inclusion of post-trial justice into evaluation. Given the focus on impunity or anti-impunity, it was all about getting the conviction, and perhaps we haven't thought enough sufficiently about what happens after the conviction. So a lot of legal schemes, I would say, are missing from the discussion. How do we treat relocation? And we had already these problems in Katanga, for example, and Godula Chui cases, in which it was very difficult for them to go back, and they were facing charges in their home countries, and perhaps even inhumane or degrading treatment it may arise in future cases. So nowadays we are dependent on cooperation of member states, and even when this cooperation exists during the trial phase, it often ceases after the trial ends. So we have a very low number, I would say, of sentence enforcement agreements, and even a lower number, actually just one agreement on the release of an ICC detained person. It was signed by Argentina, and having in mind the structure of the defendants, I think you would agree that perhaps it's not the most likely or the best option for the released persons to move and to relocate, for example, with their families in Argentina. And these agreements, I have to add, are double consent agreements, which means that even once they have been established, the country must accept, again, a concrete person. And there are a lot of costs associated with this, because this should be bared, these costs of relocation and everything should be bared by the states. And just another issue that I want to mention, Simatovic, if I'm not mistaken, by the ICTY, was recently conditionally released because of his illness and inability to treat that illness within the prison, and there is no legal scheme currently at the ICC for compassionate release. There is only a possibility for sentence deduction after 2/3 of the sentence have expired, and there is no possibility for conditional release, for example, to bring that person back should the circumstances improve. So I think that this is something that we should dedicate more efforts to. So I made it to the last slide, and I may have not started poetically, but I hope to end poetically a little bit. So what I'm asking here is to compare the ICC with the fairy tale you may remember, Goldilocks and the Three Bears. It was, it was for her, when she went into the cottage, it was always one was too hot, one was too cold, the porridge. One bed was too soft, one was too hard. So can the ICC get its porridge right? And we have seen that, given so many underlying values, given the vertical and horizontal aspects being combined into one court, it's always, I would say, it's easy to criticize the court from one or the other angle, to legitimately criticize the court. And it's also, when we talk about effectiveness, it's really, we can ask ourselves whether this is something that can be measured, whether we have metrics that can be objectively used. So I'm afraid I don't have the answer to all of these questions, but I want to end by quoting Daryl Robinson's piece from 2015 already, who said that the deep tensions at the heart of the project are impossible and beautiful and frustrating and inspiring. But as a final paradox, the impossibility of the project need not undermine its necessity. And with that, I thank you for your attention.